Emergency content. By 999. Just try.
Thank you. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 2.
2.
Yes, Your Lordship.
Why? This is an admission matter?
Yes, Lordship, the conducting counsel, she is not feeling well, that's why I'm appearing on behalf of him.
This is otherwise what? A criminal petition?
Yes, Your Lordship.
Not for quashing, something else?
No, Lordship, I don't have any idea. I'm appearing on behalf of her.
Okay.
Yes, Your Lordship.
You'll do it next week?
Lordship, after 3 weeks.
After 3
or
weeks?
19, yes, Your Lordship.
This is 23 matter, not yet admitted.
Yes, Your Lordship.
Right. You can tell your senior to do it next week, Tuesday?
Next week, please.
Okay. Miss So-and-so appearing for the petitioner. I think the service is also not complete, right? Service is not complete. Nobody seems to be appearing on behalf of respondent.
No.
Okay. Oh, you are there. Acha, your name is not reflected.
Yes, Your Lordship.
Acha, I heard Miss So-and-so for the petitioner and Mr. So-and-so for the respondent. Prayer is made on behalf of the petitioner that the conducting counsel has some personal difficulty. The conducting counsel is not well. As such, prayer for adjournment is met. Prayer is allowed. List the matter next week on Tuesday. And the name of Mr. So-and-so may be reflected in the cause list for respondent number 2, for the sole respondent. Yes.
Please, Your Lordship. Lordship, I beg to mention hearing item 15.
15.
Lordship. Lordship may be gracious enough if this matter be fixed on 4th of August.
Why not?
Because
Why not today?
Because the leading counsel, Mr. Aju, is currently on leave.
You are for the respondent. Mr. Zamir is dead.
Senior counsel is on leave. So I wanted to do it next week.
Okay.
But then next week, again, they are expressing some difficulties.
Okay. We have some fixed matters, so
Then-
Lordship.
Today is also fixed with a Kansana Putta party
So,
as a fixed item. But then
okay.
my learned friend, the senior counsel, has taken leave. So,
Lordship.
Okay, I'll give a fixed date on that day.
Lordship, yes.
Mr. So-and-so appearing for the respondent. What respondent?
1 to 3, Lordship.
All the respondents.
Lordship.
For the respondents, praise that his senior,
Mr. Aju.
senior has some personal difficulty and has prayed for adjournment. The prayer is not objected to by Mr. C.T. Zamir. learned senior advocate. List this matter on
Lordship,
on
4th of August. we
4th of
consider-
August. Okay.
As a
That day you
fixed
don't again pray for adjournment.
No.
Yes.
And there
List
is an
of-
interim that may be continued.
4th of August, interim, passed earlier, shall continue till the next date.
Much obliged.
Mr. Lordship, I beg to mention hearing item number 6. Lordship, if this matter can be listed after 3 weeks, since my senior is indisposed.
Why do it? All hearing matters gets adjourned. Yesterday also I have seen. 2 day matters. Right. Otherwise, what is the purpose of keeping it pending? And there are interim orders and people enjoy and then keep it. This is not done. You should do it. You do it. You take the opportunity. Item number 6.
Yes, Lordship.
Yeah, for the petitioner.
Yes, and for the petitioner.
Do it today.
My senior will be agreeing.
Next time you do it, you come prepared. Miss So-and-so appearing for the petitioner prays that her senior is indisposed and has prayed for adjournment. Mr. So-and-so appears for the government, for the respondent,
Yes, for the state respondent.
for the state respondents. Prayer is allowed. List the matter on. I'll give you a date then. This is 21 matters. See, 5 years have gone by. On 11th of August. Now, do it then. This is, see, so many years have gone by, 21 matter.
Yes, Lordship.
On 11th of August.
Lordship,
Obliged, madam.
Lordship, there is an interim.
Our interim order passed earlier shall continue. This is the reason. Then don't do it anymore. Next time I'll not give adjournment.
Deeply obliged, madam.
Okay. Yes.
Please, Your Lordship.
No more hearing adjournments. What?
Your
What?
Lordship, I'm appearing on behalf of H.E. lawyer. He is an outstation lawyer.
Item
For
number?
item number 16 and 17.
I'll tell the
Your Lordship,
registry
the
not
principal
to
lawyer
list.
is indisposed, so kindly fix the matter on
16
20.
and 7 bail matters. You can do it.
Your Lordship, I'm not a counsel. He is an outstation lawyer. The standing counsel is also indisposed.
This is AB. Why do you take time? In respect of 16, 17 rights, the council.
Here is an
Oh, see, interim bail. And then case diary is here, or what it was called. Case diary was called perhaps.
Yes.
Case diary is here.
Yes.
So, do it.
Your Lordship, I have no idea about this because I was just instructed by the senior counsel to.
Mr. T. Pongenar is there.
Tumchin Pongander is also he is also indisposed.
Oh.
He's in free right now.
Your Lordship, on last occasion I filed my Bakalatnama for the complainant.
Achha.
So whether I was impleaded in the case or no, that I'm not very sure. So if please I may be impleaded in the case to defend the complainant and assist the petitioner.
And they have already perhaps made you a party, but then it's not reflected in the cause list.
Yes.
Because AB complainant is not required, you will only assist the PP. Right.
Because Your Honor, now
You have filed an impleading application.
I filed my Bakalatnama only.
Wakalatnama, you are not made a party. How can you file a wakalatnama unless you are impleaded?
So Your Honor, I'm praying that I may be impleaded.
You file an impleading application.
Your Honor, yes.
Okay.
Okay.
Mr. So-and-so appears for the petitioner. And Mr. K. Angami. K. Angami? Yes, K. Angami, public prosecutor. The public prosecutor for the state of Nagaland. Mr. So-and-so prays before this court for an adjournment on the ground that his senior is indisposed. And Mr. Kobi appears before the court with a prayer that he will be filing an impleading application or appearing for the you don't have the right to appear now because you are not a party. You file an impleading application, not required. Okay.
Most obliged.
And then prayer is allowed. List this matter on next week.
29.
29 is not next week. 24th. AB only. Case diary is there. He has to retain.
Next week I have difficulty.
Acha.
I cannot come, so it may be listed as prayed for by the.
Okay. Fix it on 29th. Case diary to be retained till then. Okay. Oh, interim order passed earlier shall continue till the next date.
Like, please, my lady, we have a joint prayer, item number 5. This is 2020 case, but we were, both of us were under the impression that item 7 and the last 2 items were to be taken up. But after this morning, we were told that other parties are seeking time, and I could not prepare for this case, item 5.
Item 5.
Yes, so if this may be listed after 2 weeks.
Acha.
Yes.
This is a criminal revision 20.
Yes, yes.
Mr.
Yeah,
Zamir Angami, for the public prosecutor, prays before this court that the matter may be adjourned and to be taken up after 2 weeks.
Ladyship.
After 2 weeks. Prayer is allowed? Oh,
I have no objections.
Mr. The adjournment is not objected to by so-and-so. List this matter on when? This is 20 matter, so I'll give you a date. When? Next week, not possible. You are not there.
I have difficulty.
Acha. Then 4th of August?
Okay. 31
Chalo, fine.
31st July, if it is like lady.
Okay, fine. List it on 31st July, as agreed by the parties.
Deeply obliged.
Thank you, Your Lordship. First, I'd like to mention hearing item number 7, Your Lordship. I'm making
7 is criminal appeal, jail, do it. You are amicus.
No, Your Lordship. Amicus is Cynthia.
No,
I'm
I mean,
making
this
mention on behalf of,
is not a jail appeal, this is a regular appeal.
Lordship, the leading counsel is from Dimapur, Your Lordship. I'm making a mention on behalf of NK Lucam. He's indisposed today, Your Lordship. So I pray this may come up after 2 weeks.
This is otherwise not a jail appeal. I don't see amicus curiae on behalf of the petitioner, appellant. You are for the respondent, I think.
I believe the appellant is already out on bail.
Yes, yes. It's on bail.
Of, under suspension of sentence.
Yes, yes.
Okay. Do it, you cannot.
I'm not the counsel, Your Lordship. I'm a proxy counsel.
There are 3 counsels here.
Both are from Dimapur, Your Lordship.
Okay. The
Otherwise, both of us are ready.
appeal jail, there is, I mean, this thing, the LCR is there.
No, we have,
But then it is not reflected in the cause list about the LCR.
we have only have a paper book.
A paper book is prepared. That means the LCR is here. It's not reflected. Okay. Heard Mr. So-and-so appearing for the petitioner. And it is T. Angami, the additional advocate general, additional public prosecutor, as well as Mr. Santianger. Santianger, the amicus curiae appearing for respondent number 2. Is this a POXO matter?
Yes.
Otherwise, respondent number 2 amicus, no? Okay. A prayer is made on behalf of the counsel appearing for the petitioner that the counsels are the leading counsel is indisposed. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Much obliged, Your Lordship.
Much obliged.
Please, Your Lady. Item 4, on behalf of Livika, PP, I pray this matter be listed after 2 weeks.
On
She is
behalf-
indisposed.
On behalf of the government advocate,
Yes,
PP,
PP.
she is
She
handling
is
the matter.
indisposed. Yes, she is handling the matter. Yes.
Miss so-and-so, you are also PP?
Yes, yes.
The public prosecutor for the Naga, for the state of is praised that the concerned public prosecutor who is handling the matter is indisposed and as such has prayed for some time. The adjournment is not objected to, prayer is not objected to by Mr. Moazamir.
Yes, Lord.
Yes, Mr. Moazamir. List this matter after 2 weeks.
Your Ladyship, I would also like to mention item 10 and 11. Here I have a prayer, Your Lady. Your Ladyship, I have received some documents which are relevant and necessary for deciding the matter. So I may be allowed to file additional affidavit.
Okay. Miss so-and-so, in item number 10 and 11, right? Miss, you are also a
As
government
a-
advocate?
Yes, yes.
As well as
For the
public
state.
prosecutor?
Yes, yes, public prosecutor.
Okay. Government advocate submits before this court that she has received certain documents which are relevant for the adjudication of the present case. She as such prays to file an additional affidavit incorporating those documents for bringing into record those documents. Prayer is allowed, list the matter after 2 weeks.
Gratefully.
May I please, Your Lordship? Your Lordship, I beg to mention hearing item number 8 and 9.
18,
8 and 9.
8 and 9. All hearing matters are mentioned, see? 8 and 9. Why? What happened?
Your Lordship, I pray the matter will be listed on Thursday, 24th.
Oh, on this Thursday. Why not today? 24th.
Next
Hearing. Acha. Thursday. Okay. As prayed for by Miss So-and-so, appearing for the petitioner, list the matter on 24th of what? 24th of July, 2025.
Your Lordship, I also beg to mention item number 12, 13, and 14.
Again, 12, 13 and 14.
Your Lordship, I pray the matter be listed after 3 weeks.
You are there for the petitioner?
Lordship,
No, no, respondent.
my colleagues, Lordship. Our Lordship, I have no objection.
Acha, you are for respondent?
I'm for the state, Lordship.
A state respondent. You are also appearing? Okay. So, heard Miss So-and-so and the state respondents as well as the private respondents. The counsel appearing for the petitioner. Why do you want time?
Your Lordship, my senior,
What? Yeah, I mean, the entire list is gone. See, none of the matters are left.
my senior needs some time.
What is there in the supplementary? Okay, there are few matters in the praise that her senior has some personal difficulty to appear in the to conduct the case today. The prayer is not objected to by the counsels representing the respondents. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry. Okay.
Mashallah, Lordship.
My blessed Lordship, Lordship, I beg to mention item number TD2 to TD2 for the supplementary list, Lordship.
20,
TD1 and TD2.
20, 21 and 22. These are our analogous matters. These are AB.
Yes, yes. Lordship,
Bail matter.
My lord, in this matter, what happened, I preferred an AB. The learned court at that point of time refused to grant me the bail. So we approached the Honorable Supreme Court. Supreme Court granted the bail, saying that till the matter is decided, the AB, I will be given interim protection. So accordingly, we filed our order of the Honorable Supreme Court. The matter was fixed yesterday. Yesterday for hearing.
Where? Here.
Yes, it was hearing. But it was been told by the registry that it will be listed today in supplementary. So accordingly, the matters are posted here. The issue is that petitioner number 1, that AB 19, I suppose, he happens to be a retired former district and session judge.
Achha.
Matter involves a very substantial questions also.
No, what? You said that they were already allowed bail by the Supreme Court.
No. I asked for interim bail so that I can take part in the investigation. The High Court said that no, we will call for the case diary. So we approached the Supreme Court. So Supreme Court said that since the High Court has called for the case diary, bail should have been granted. The certified copy has been given, even though this is the order of the Supreme Court.
Okay.
So accordingly, the matter was fixed on 17 for hearing, final disposal. I took part in the investigation.
Yes.
My Lord will kindly come to.
Today,
Lordship,
what is the difficulty?
Lordship, I on behalf of my colleagues and to the Lordship, he have some personal difficulties. So if this matter be kindly list on Monday, Lordship.
Monday. You are not handling the matter.
Lordship.
I'll just see the Supreme Court's order. We have perused the impugning order. Since the High Court has deemed it appropriate to call for the case diary for further, the revelation should have been granted the benefit. Decided by the High Court. Is granted period subject to cooperating with the investigation till so and so is finally decided by the High Court.
Yes, exactly.
So he is not inside, he is out only.
He is out only.
Yeah.
So I appeared before the IO. I have given my statement. And there were certain orders also passed by the High Court, because when we applied for the certified copy of the FIR and the relevant documents, the CGM refused to give us.
Oh.
So we apprised this Honorable Court. The Honorable Court said, no, you have to get it. So the CGM given us the copy. And the issue is that very simple issue. When you get a bail, you have to give a bail bond. So in Nagaland, there is no concept of bail bond also.
Huh?
Yes, very surprising. Now, for example, in our High Courts, Gauhati High Courts and all, we
In
have.
fact, I allowed furnishing on a bail bond and all. So what will happen?
They don't deposit in a treasury.
Acha.
They kept it in a particular bank account. So this was the issue which I flagged it when I was a CGM, Kohima. That to the honored protocol judge at that point of time that look, this is a thing, a very serious concern, because when you get a bail bond, that amount has to be deposited on a concerned head in the state treasury. Because for a lot of reasons, because the High Court rule says that.
Yes.
As far as Nagaland is concerned, the government has not framed any rules. In fact,
Government has not
framed any rule.
Oh.
No, the money has been deposited in some lawyer's account, some judge's account, some court staff's
No,
account.
those High Court rules will be applicable.
Exactly.
Huh.
So I flagged it.
Ah.
That was what I presented before the Supreme Court on my SLP. The Supreme Court was also shocked. So the question is that amount of rupees 10 lakhs, if I am not wrong. How much? 14 lakhs 35,000 was found to be missing.
Acha.
So my argument was that when I handed over my charge to the Chief Judicial Magistrate Dimapur, so it was done under the Assam Financial Rule 145. So the handing over and the taking over officers, they have to make an endorsement with all the balance of accounts that everything is fit and fine. So it was being done. So subsequently when I went out to my new assignment, some vexatious perpetrated.
You were a CJM then?
No, I was a district and session judge at that point of time.
Okay.
So what happened? I handed over my charge to the Chief Judicial Magistrate as per the order. So I proceeded to MOM. So nothing was going on, everything was fine. So subsequently some departmental proceeding was drawn against me in relation to some other matter. I was given compulsory retirement without conducting the inquiry. So those all issues are pending before the High Court. Even we went to the Supreme Court over a discipline that with respect to pension rule, the Supreme Court said that you raised this issue in the review petition. So liberty has been granted. So those all are there. When this matter was pending in the High Court regarding that compulsory retirement, on 26, they registered an FIR. The district judge registered an FIR. So our main question was that as far as the handing and taking over documents, it is perfectly fine. That there is no pilferation of money. Now I go back to my place and I flag these issues in a seal cover I have given also into the High Court while the hearing was going on. Seal cover that how these discrepancies are going in the state of Nagaland. So I flagged it.
Money was missing from the bank. Somebody had drawn it over.
Normally what happened is, I have been told, there is a cash register is there, their court staffs are there. So these two persons, the co-accused, one happens to be the account officer, one happens to be the... So I pass the order. Like for example, a special case is there. So normally what happens, it is before the CGM, till before the committal.
Yeah.
So they come to 439. I pass the order, whether granting or refusing. If I grant, I will say that subject to the satisfaction on a trial court with a bail bond of 30,000. So no session judge will take 30,000 in cash. So what they do in Nagaland practice is that they will bring the cash, give it to the court staff, he will make an entry, and that court staff will give it to the other person, he will go and deposit in the bank.
Gotcha.
There the question is that where does money go? So it comes to me, I will see the order sheet and I will sign it. That was my limited role.
Okay. Okay, we will see it on Monday then. You have to stay back or come again. Or you can do it today. Case diary is there.
Tomorrow principal court is open. Principal Gauhati.
Is it?
Yes, tomorrow we have got the cause list. Tomorrow Saturday court is open.
Okay.
So with a permanent.
Even I don't know. Tomorrow this court is open.
Because principal seat is open.
Has to be then.
Yeah, we can do it tomorrow, my lord.
Tomorrow can you do it?
Since the concern in this matter is have
No, Monday data.
So if this matter will come up on Monday, Lordship.
Otherwise, case diary is here. You have information.
Lordship, I have no instruction.
Because last time it was called for and
Yes,
then
exactly. Case diary will be
it
here.
will be here, I think. But again, if it is not here, then we'll have to again
Because the
give a
problem is
date.
what is there. Your lordship, the problem is what is there. Let me be very frank, as far as I am concerned. Because of the pending of this proceedings, when we went into the High Court for our compulsory retirement matter and the other disciplinary proceedings, I anticipate that if there is an order comes in my favor at any point of time, the government may use these proceedings to initiate a fresh inquiry. That is my grievance, my apprehension is there. And a very serious issue,
We will
lordship,
look
very
in-
serious issue.
And the case against his compulsory is pending before High
Compulsory
Court.
retirement is pending before the division bench. So it will be taken up by most probably by the new chief justice will come and take up the matter because the earlier they could not take up the matter.
Now we are with the only AB.
Yes.
So, but try to do it tomorrow. You can let me know after some time, speak to the concerned PP. Okay? Let me know after some time if it can be done tomorrow. Okay. As prayed for by Ms. So-and-so, learned APP, who states that the learned PP who is handling the present matter is indisposed and has prayed for some accommodation. List the matter tomorrow. Oh, not tomorrow. You come and give us the instruction.
Exactly.
Okay.
Yeah, Mr. Lordship. Lordship, I beg permission, item 3, on behalf of appeal to
Item 3.
Yes, Lordship.
I'll have to rise at 12, I think, 11, I think. Item 3 for what? Why?
Lordship, recommended we can leave come after a week.
Why? What is the reason? It's only admission?
Lordship. Yes, Lordship, to get some instruction from the client, Lordship.
You're there?
Yes, Your Lordship.
For the respondent?
For appellant, Your Lordship.
You're for the appellant?
Yes, Your Lordship.
What do you say? You have no objection?
No objection, Your Lordship.
You are for the respondent?
Yes, Lordship.
Actually, you should change the either side or what? Okay. So I got confused. Okay. Learned counsel for respondent number, sole respondent? No.
1 and 2.
Respondent number?
1 and 2.
1 and 2 submits that he is yet to get certain instructions from the client and has prayed for some accommodation in the matter. The prayer is not objected to by Miss.
Esther, Your Lordship.
Your name is there?
Yes, Your Lordship.
Achha. So and so for the petitioner has no objection. Prayer is not objected to by so and so. List this matter after a week. I'll give you a date or on a date to be fixed by the registry.
Much obliged.
25 matter. Okay.
For motion from the supplementary cost list, item number 18.
What happened to item number 1? Is there, no, on board? One of the main
Yes,
list.
1 is there. When is the 1?
I beg your pardon.
It's
For motion, item number 1.
1. This is a bail application.
Yes, Lordship. May I please, Your Lordship? Lordship, this bail application is filed seeking for the release of the alleged accused person arrested under Section 21C of the NDPS, right with Section 5.3 of the BNS, Lordship.
So
Lordship,
NDPS commercial quantity.
Yes, it's commercial, Lordship.
So let the case diary come.
Lordship.
And is the trial on?
No, Lordship, it's yet to be charged sheeted,
Oh,
Lordship.
charge sheet is also not submitted, right?
Yes, Lordship.
So let the case diary.
Lordship.
Okay. This is an application under section 483 of the BNSS 2023, read with section 37 of the NDPS Act for grant of bail of the petitioner in connection with
Petitioner is the father of the alleged
okay,
accused.
in grant of bail of the accused person in connection with the suburban police station case number 27 of 25, registered under section 21C of the NDPS Act and section 35 of the BNS 2023. Call for the case diary. List this matter on. When can you bring it? This is from where?
From Dimapur, Lordship.
Dimapur, so you can bring it next week. List the matter on 24th. List the matter on 24th July
To
2020.
be on the much safer side, 25. 25 on Friday.
25 Friday I'll not fix up matters because I'll be going again. So 24. Try it. If you can. If you are not able to, then we'll get another day. But try to get it.
Much obliged, Lordship.
For motion, item number 18.
Yes.
This one, Lordship, this is a petty case. Right?
a petty case, a minor offense case.
Acha.
Compromise has been reached between the parties.
Okay.
The victim.
This is not a joint petition. There are respondents.
Yes, yes. We would have filed a joint petition, but earlier in similar matters, the opinion of this honorable court was that the victim must also be made a party respondent, so that she will file a separate affidavit as to assuring this honorable court whether the compromise was actually reached or not, which is why we have made the victim a party. The compromise sheet we have already annexed to our petition.
What is the offense?
The offense is section 118 and section 75 of the 118 PNS, that is
What is that?
previous hurt.
Huh?
Hurt and previous hurt.
Oh, grievous hurt.
Yes,
Yes.
but the issue does not arise at all. Secondly, section 75 of the JJ Act, Juvenile Justice Act. Section 8 of the POCSO was also there, but it was removed by the Honorable Court by order dated 21/3/2025.
Charge sheet is submitted.
No, charge sheet is yet to be submitted. And the victim was staying as domestic helper in the house of the petitioner. So on that fateful day, on coming to learn that she was stealing some household items and selling it to his neighbors, and when the neighbor came, how much the cost will be, all those things were discovered. And then this was not the first instance of such incident happening in the household, but in the family. But on the hope that she will change.
She was kept.
Yes, she was kept after giving proper advice, but it kept happening time and again.
So the house owner had lodged the FIR.
No, not the house owner, in fact. So the house owner, the housewife, she beat her with a stick.
She has beaten her up with a stick.
Yes,
Oh,
twice or thrice. Now,
she lodged the AJ.
yes, the victim's community, the tribe, they have an organization, an association in Kohima. So that association, they filed the FIR.
So let the notice go to the victim today.
Yes.
Okay.
But in the meantime, if the proceedings can be stayed.
Proceedings means only investigation.
Yes.
Investigation should not be stayed at
stage,
We'll give a short date. Let her come back with the
My
affidavit.
lord.
And this is an application filed under 582, section 582 of the BNSS 2023 for quashing of the FIR and the consequential criminal proceedings in connection with Women's Police Station case number 11/2025, registered under section 118 BNS, read with section 75 of the Juvenile Justice Act. Where is the FIR?
Annexure 2. Page 16.
The prosecution story, as is revealed by the FIR, dated 17/3/2025.
Yes, 17/3/2025.
2025 reveals no, you cut that sentence. The FIR dated 17/3/2025 was lodged by the Vice President of Yungking Labiri,
By the Vice President as well as the President. Yes.
as well as the President of,
In Kyong, Lipiro, Area Hako.
you can take it from YIMKHIUNG, then LIBERII.
This is not double I, this is that you,
This is not double I.
no.
Liberiu.
Yes.
You.
Yes, you.
And then ARI
HA?
HAKO
Yes.
Kohima, right?
Yes, my lord.
alleging about the physical and emotional abuse of the victim at the house of the accused person,
Yes.
namely Mrs. Ginia Cage Kat. And on receipt of the said Ejahar, the police registered the case under the aforesaid sections. The counsel appearing for the petitioner, however, states that pursuant to the FIR, where is that really?
Compromise 3 to set.
Yes.
Annexure 3,
An agreement was reached between the parties,
page 18, my lord.
wherein have agreed upon that they have entered, they would no longer pursue the case between them, and that neither the party concerned will pursue any further case against each other.
My lord,
Inasmuch as there was a deep bonding between the parties, and the said FIR was lodged under a misunderstanding. Issue notice.
my lord, the FIR has also been withdrawn by the complainants.
This is in the agreement.
No, it's in Annexure 6.
Oh, is it?
Yes.
6.
Yes, the prayer for withdrawal of FIR addressed to the officer in charge of the concerned police station.
Further, the council places the letter dated 21/3/2025,
My lord.
addressed to the officer in charge of the North Police Station, wherein the complainants have prayed for withdrawal of the FIR lodged against the accused person. That is the petitioner. Petitioner?
Yes, my lord.
Petitioner. Issue notice to respondent, so-and-so appears, Miss so-and-so appears for respondent number 1. So no formal notice is required to be served upon her. Extra copies, or you have copies? Also. Notice the petitioner to take steps for service of notice to respondent number 2 to 5
By registered AD as well as trustee service.
by registered AD, by registered post with AD, as well as
Dusty
usual
service.
or dusty,
Yes, my lord.
as well as usual process and dusty service. The petitioner is allowed to file an affidavit after service of notice by dusty, if any.
My lord.
List the matter after 2 weeks.
Much obliged.
Regarding item numbers 20 to 22, I have confirmed from the section that there is no court hearing going on tomorrow.
Oh, there is no court in. How come principal city is having court?
Yesterday I was also shocked.
I'm new here, I don't know. Acha, so then do it on Monday?
Monday, let it be at the top of the list, my love.
Monday?
Monday.
Yes, yes.
Because if we have to go back, because road condition is so pathetic at present.
Yes,
At
yes.
afternoon it's very risky. So if you can top of the list, my lord, it will be convenient for me.
Lordship,
This is,
Lordship,
in fact, the PIL is pending for improvement of the road from Dimapur to Kohima.
I was in that, but
Yes.
topography is certain way.
Yes, I understand. Okay, now so.
Lordship, I have received the information and he's out of station. So can you list this matter on Monday?
Monday, okay. Not on the top of it will reach, don't worry. As prayed for by Miss So-and-so. 20 something, right? What was the matters? 2021, okay. So don't write that. Miss So-and-so, the public prosecutor Nagaland submits that the conducting counsel, the concerned APP is handling the case, is
Lordship.
indisposed,
Lordship.
right? Is handling the case is indisposed, and I have prayed for some time. Mr. S. Borgohai, appearing for the petitioner, however, objects to the prayer of adjournment. Since the learned PP is indisposed, list the matter on Monday, that is 21st of July 2025.
Case diary is there, madam?
Case diary is here.
Case diary is there?
Yes, we have already received. I will go.
Ms. So-and-so also apprises the court that the case diary as called for by the last order is received. List the matter on 21st of July.
For motion, item number 19.
This is a criminal petition.
Lordship,
For what? Quashing?
Lordship,
Yes.
I'm petitioner and person Lordship.
Oh.
This is a questioning matter for questioning the criminal complaint before the GMFC and for the consequential proceedings. The brief fact is that the petitioner
You are praying for the quashing of
Quashing,
the
Lordship.
criminal complaint.
complaint.
Okay.
What happened is that the petitioner number one, respondent number one, and we are common friends. Common friends. So we approached the respondent number one to extend his helping hand by adjusting 10 lakhs for 2 weeks. And accordingly, he gave us the money on the 5th of December 2021. And my lord, after 40 days, that is on 15th of January, we made the repayment of 5 lakhs. 5 lakhs. However, admittedly, because of financial constraint, we couldn't pay the remaining amount. And for which he approached the criminal court and filed this complaint with sole ulterior motive to harass us
420.
for 5 lakhs remaining.
No, section 420.
406, 415, 422, 24, and 34 IPC.
Otherwise, you have already paid 5 lakhs.
Lordship.
Initial deception perhaps is not there.
No.
Otherwise, you would not have paid at all.
No.
So let me see the complaint.
Lordship.
Are you praying for any interim and all?
Lordship. Do stay the pending proceeding before the GMFC by my Lordship.
Acha, let me see the complaint.
It's on page 20, Lordship.
Page 20. What are the further proceeding? I mean, any direction to the police to conduct an investigation? No.
No, Lordship.
And cognizance वगैरह?
Cognizance taken?
Cognizance taken?
Yeah, and remove the section 415 and 24 IPC.
What? Cognizance was taken?
Cognizance taken, and for the only the section 406 and 422 and section 34 has been taken cognizance constituted against us.
Oh, under that cognizance was taken. Just go read the complaint once.
Lordship.
Yeah, read the complaint 21.
Petition, the entire petition, Lordship.
No, the complaint. Page 21, the complaint.
Page 21. Lordship, Para 2, page 21. During the year 2021, the complainant was approached by the accused number 1 and 2 through a phone call stating to lend them some amount of money on the pretext that the accused persons had availed some contractual work and to which they need to pay an amount of rupees 10 lakhs for the GST deduction.
He has been paying interest, right? He
That is what
he borrowed the
alleges.
money. Okay, let me go through the entire. More than a year passed now, right? Legal notice was served.
Lordship, yes. And it was replied on 29/9/2024 comprehensively. However, that is not brought before the lower court and the petition.
Let me go through. Where is the cognizance order?
Page 34, Lordship.
What is 422?
422 is preventing the dishonestly and fraudulently preventing the money, preventing the accused to
Achha, this is IPC.
IPC, Lordship.
Why IPC? 2025?
2025.
When is the FIR lost? Date?
It's complaint case,
Oh,
Lordship.
complaint?
Yes,
When was
Lordship.
it? It
It was on 28th, January 2025, Lordship. Yes.
It should have been under the BNS.
Yes, Lordship.
Give me IPC.
DNS.
No, IPC. 422. IPC. Have you taken the ground that the case should not have been taken cognizance under IPC?
Lordship.
You have taken the ground.
Lordship.
Now the accused persons, the complainant had taken money from others and had given to him, right?
Lordship.
Yes, he had borrowed the money from others with interest, and had given you the money initially.
Lordship, that's the story of their side, but then there is nothing on record as such.
Yes, but if he had not the money, he should not have paid. But taking it from others, said he had given it to him because they were all friends, right? They were all friends.
We are friends, yes, Lordship.
But the ingredient of initial deception is not there in 422.
Lordship.
So 422, 406 is misappropriation, okay, fine. 422, whoever dishonestly and fraudulently prevents any debt or demand due to himself or to any other person from being made available. Because he had taken the debt, demand due to himself or any other person from being made available according to law for payment of his debts or debt or the debts of some other person shall be punished. Otherwise, he is not paying for so many years, 3.5 years, not even months. And he was supposed to return it within 2 weeks. So he is not paying him deliberately in a way.
Lordship.
422 is met out.
Lordship, however, my plight and difficulties cannot be misconstrued as preventing him from availing the loan also. In my petition also, we have cited that we requested him to even pay him some money.
Where? What? Which paragraph?
In his petition, Lordship.
In the complaint?
Yes, in the complaint, para 8. Para 8. Last 7 lines. May I read out, Lordship?
Course of their sitting.
Yeah, during
he
the
paid
course of the
rupees
sitting,
1 lakh.
yes.
No, normally it happens, well, not take part of the amount, I have to take the entire. This is what happens.
Lordship, at the most, this can be a civil dispute. And the respondent has effective remedy before the civil court. Unless he has the other intention to harass us.
And that is another aspect. I have to see whether criminal element is there in the complaint. As far as 422, the ingredients are there. Misappropriation is also there. He has 5 lakhs he has not paid till date, along with the interest also. There is no agreement to pay the interest.
No agreements. The agreement, money receipt is on page
Where is the money receipt?
Yeah, page
He did not sign the agreement according to the complaint. Where is the
Page
money?
28, Lordship.
Page
Page 28.
28. So it was only for 10 lakhs.
Only for 10 lakhs. And next page is the repayment.
Received a sum of 10 lakhs only from in cash for a period of 2 weeks. Received a sum of 5 lakhs. Remaining amount yet to be amounting to 5 lakhs. Okay, that you, of course you did not pay in time, but then you had paid 5 lakhs and 1 lakhs. What do you say, Mr. VP? Whether for 422, 406 is there, misappropriation, okay? Of course, we are not in Quashing now. We are only with the interim
Lordship,
prayer.
406 is criminal breach of trust.
Oh, yeah, criminal breach of trust.
Yeah, so without entrusting any property, this ingredient is not established, which your Lordship knows.
Yeah, breach of trust will be there. You are entrusted with the money and then you did not pay. Right.
But Lordship, there is no means here. Us, we have paid the amount also, but it's only our difficulty, that's why that we couldn't pay.
Where is your pleading that you were facing some difficulty, so you are unable to pay?
Lordship, we have replied in our affidavit, legal notice, Lordship.
In the petition?
In the legal notice, reply to the legal notice served by him.
No, in the petition where you pleaded that you are not able to pay the money because of financial constraints.
Lordship, I have just mentioned in the grounds about the serving, replying in the legal notice only, Lordship. Since it is only the question matter, that's why I didn't go to the merit.
You said this giving money in the manner of helping will not be equated with entrusting of property. That of course will not. Yes, what do you say, Mr. P?
At this stage, if notice may be issued in the interest of justice.
Notice may be issued, that is okay, but then he is praying that interim.
Internal, as far as interim is concerned, since the main party is not here, I don't know whether at this stage, if that opportunity.
Now that only cognizance is taken, right? Summons were issued and all. No further. Only cognizance is taken.
Lordship, if the private parties are aggrieved by the vacation, then they can always file for the vacation of this. If they are aggrieved by
vacation of interim.
yeah.
It's okay.
Otherwise, the very purpose of filing this petition will become infructuous.
What is the next date fixed?
It's on Tuesday, Lordship, for EPC.
What is this, page 38? Central office, what is this?
These are all annexures, Lordship.
Somebody is standing for some elections.
Your Lordship.
The accused person or the complainant?
Complainant. So I'm not going into the details of the story, but that is how we have helped him during elections also.
Okay, this is an application filed under section 528 of the BNSS for quashing of the criminal complaint number 1 of 2025, pending before the Learned Judicial Magistrate First Class, Kohima, for offences punishable under section for offences under 406, 415, 422, 24 and 34 IPC. The petitioner has also challenged the cognizance order passed by the Judicial Magistrate First Class Kohima dated 27/2/2025 against the petitioners for the offences punishable under 406, 422 and 34 IPC. The complaint dated, what is the date of the complaint?
It's not mentioned, but most probably it's 27 January 2025, Lordship.
27 January.
Lordship.
The complaint dated 27 January 2025 reveals that the complainant, on being approached by the accused persons, paid an amount of rupees 10 lakhs to be repaid within a period of 2 weeks. The complainant further states that he had taken loan from another person on interest and had paid an amount of rupees 10 lakhs to the accused persons. However, the accused persons had failed to return back the money, and that he is facing immense hardship and irreparable loss. He further stated that after more than a year, the accused persons on repeated request paid an amount of rupees 5 lakhs on 15/1/2022. This will be after 1.5 years, right?
Actually, it's only after 40 days, Lordship, we have paid.
Acha,
Yeah, but he mentioned us more than a year.
he mentioned, this is what I'm saying, this is what. 5 lakhs, yes, as a part payment. And with the further assurance that he would repay the money within a short time. The complainant, however, states that after that, nothing was paid. And then, on a subsequent request, the accused persons approached to pay an amount of rupees 1 lakh to the complainant, but he did not receive, on the grounds that the entire remaining amount should be paid to him. The complainant thereafter served a legal notice upon the accused persons. On receipt of the complaint, the court and on perusal of the same, where is the cognizance order you showed?
Page 34, Lordship.
And after hearing the initial deposition of the complainant and the witnesses under section 200 CRPC, the learned court took cognizance of the offence under section 406, 422 and 34 IPC. The learned counsel, oh, you are not you are appearing personally.
I am in person, Lordship.
This is which matter? 19.
19, Lordship.
Mr. Kelly, K-I-E-L-I-E, appearing personally.
H. Makam, Lordship.
Oh, H. Mukam. Mr. H. Mukam. You are one of the accused person.
Lordship, I'm accused number 2 in the complaint.
Appearing personally before the court, submits that there is no intention of the accused persons, on the part of the accused persons, not to pay the amount to the complainant. The same would be substantiated by the fact that he had paid rupees 5 lakhs towards payment of the entire amount, and that he had again tried to pay rupees 1 lakh subsequently to the complainant. He states that due to financial constraints, he is unable to pay the entire amount within the time period fixed, and that he is trying his best to pay the amount as soon as possible. On the other hand, the learned PP, appearing for the state of Nagaland, states that notice may be issued to the respondents, that is the complainant, and that after hearing them, necessary orders may be passed. I have heard both the parties. It is noticed from the complaint itself that the accused persons had given 5 lakhs has given an amount of rupees 5 lakh to the complainant on, when did you give?
15 January 2022, Lordship.
15 January 2023. It is written in the complaint.
Lordship, 2022.
I think the date is different.
But
15 January,
yes,
22
Lordship.
or 23?
22, Lordship.
22.
Yeah, it can be ascertained from the receipt also, page 28.
22, 15 January 2022, which can be seen from the receipt dated, or receipt annexed to the petition at page number 28.
29, Lordship.
Oh, 29? 29.
29.
It is also noticed that he tried to give rupees 1 lakh to the complainant on a subsequent date. However, of course, the said payment was on persistent request by the complainant. Issue notice to respondent, Mr. Angami appears for respondent number 2, and as such, no formal notice is required to be served upon him. However, the petitioner to take steps for service of notice upon respondent number 1 by registered post with AD, as well as by usual process. Since the petitioner has paid rupees 5 lakhs towards his payment of the entire amount of rupees 10 lakhs and had also tried to pay rupees 1 lakh to the complainant, this court in the interim stays there is a prayer, yeah. In the interim stays the further proceeding before the learned judicial magistrate first class, Kohima, in connection with the criminal complaint number 1 of 2025 till the next returnable date. Okay? List the matter after 2 weeks.
For hearing, item number 23.
23. Yes, Mr. Sentianger.
Yes, my lord.
Yes.
Lordship, this is a covered case.
Ah.
A case.
What about respondents? Government advocates there?
Yes,
Oh, yes. Okay. Huh. What happened?
The petitioner here, he has served the government, the department. The petitioner, she has served the department for 35 long years as a work charge employee. And from 1986 to 2021, and she has been made to leave empty-handed, without any retirement benefits.
Some inquiry. What happened?
Yes, so we have approached this honorable court praying for awarding pensionary benefits to her. Because such benefits have already been extended to so many other similarly situated employees within their department. Now, I have annexure 4. This is an RDI information that I have obtained from the department, the same department from which she was serving. The sole contention of the state respondents is that since she was not in receipt of scale of pay, because under the 2015 Office Memorandum, the regularization policy adopted by the state government, that is the state of Nagaland, a person who has served for 30 years as a work charge employee and who is in receipt of scale of pay is to be regularized on attaining 30 years length of service. Now, besides that, there is no criteria for awarding, neither seniority nor merit for awarding scale of pay. So it is being awarded in a pick and choose policy manner. So here, initially I applied for RTI application, requesting information to be given to me, like asking scale of pay being awarded since 1986 till the date the petitioner retired. However,
so she joined the service when?
1986.
Then she continued till her date of retirement.
Yes, date of retirement on 35/5/2021. That is 35 years. On completion of 35 years, because in Nagaland you cannot serve beyond 35 years.
Okay.
So the maximum period she served. So I requested the department to furnish me, the PIO concerned, to furnish me information seeking the list of persons who were awarded scale of pay since 1986.
Acha, what is the basis of their non-paying? I mean, why? What happened in between?
Like I have said, the department, they award the scale of pay on a pick and choose policy.
Acha, that is a
Yes, somebody who has not even served for 1 year, they are being awarded scale of pay. In fact, some persons who have served only for 7-8 days, even they are being awarded scale of pay. Whereas
But hers, no, scale of pay was not awarded.
No.
On the ground, that?
No ground at all. It is being awarded in a pick and choose policy. There is no policy in Nagaland for awarding. There must be some criteria, my lord.
No rules, nothing.
No rules. It's just that for receiving pensionary benefits after retirement, you must be receiving scale of pay and that you must have served 30 years as a work charge employee. That is the only criteria. Now, since criteria is already laid down that you must be in receipt of scale of pay, then there must also be some conditions on which scale of pay is to be awarded. That is totally absent at the cost of repetition. Now, a similar case was heard before the division bench. The single bench allowed the case and appeal was preferred by the state. The division bench decided the matter in favor of the work charge employee. Here also the department is different.
Here
But-
you have annexed one order of Justice Sarto.
Yes,
What is that?
yes. That same order went for appeal before the division bench.
Acha.
Division bench did not interfere with the
Okay.
single bench decision. Again, the state preferred an appeal before the Honorable Supreme Court. The state's appeal was again dismissed on 15th of January this year.
Acha. Yes, okay.
So, in other words, the decision rendered by the division bench is holding the field.
Same issues,
Yes, same
non-payment
issue,
of scale
yes.
of pay.
Yes. Non-payment of
And
scale of-
therefore, during
35 years,
retirement,
35 years, and then when I retired, I was made to retire empty-handed. So, an order was passed by Justice M.R. Patak this year, asking the state government whether the present case can be considered in terms of the decision passed in that division-based decision. However, it was not written, but the verbal information that we received was that the department is willing to abide by the decision passed by this honorable court.
has to.
Yes. And today, the matter is listed for hearing, and my humble request before this honorable court is that as per the division-based decision,
What do you say, Mr. Government Advocate? What do you say? I'm yet to go through the judgment, but then.
Lordship, Your Lordship, this has become sort of a humanitarian issue now, so far as state has been concerned. Regularizing a work church employee is not there. Lordship, you will find
There are no rules for work charge employees.
there are, but the condition is that as per the 2015 office memorandum, which I have annexed in Annexure 5 of my writ petition, at page
your leadership,
39.
You do page 39.
Achha,
Annexure 5.
let me see the Mr. Advocate. Let me see the what you are showing some memorandum. Which one is that?
Page 39, Annexure 5.
That is the same thing. That is the same thing, yes.
Oh, acha. So 39, yes.
Yes, yes.
Huh.
So
Work charge?
39, yes, 1, Roman 1.
Huh. All existing work charge.
Yes, all
All
existing.
existing work church and casual employees of various departments who are enjoying scale-up pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their posts into regular ones. personal to them and subject to fulfillment of condition as indicated above.
This has
There are
not
certain
happened
conditions
with
are
you.
there. The problem here is in the present cases, the petitioner was a work charge employee, enjoying only a fixed pay scheme. And he was accordingly released on 2021.
Yes.
Because her case is not covered by this OM. Petitioner was not enjoying the scale of pay. And
Why she was not enjoying that scale of pay? Because requirement is that 30 years of continuous service. No. Who are enjoying and who are continuing
Yes.
will be regularized. Okay, then? What is the what is the
enjoying scale of pay means that the particular employee, work charge employee, must not be a fixed pay employee.
and what is the procedure for paying a scale of pay? Huh? A person will keep on working on fixed pay for so many years. But there is no rules, nothing.
No rules, no rules.
As of today, there is no state notification of how the criteria has to be. It is usually seniority come merit.
Okay.
Someone who is very regular, someone who is sincere. So on merit, we used to grant the scale of pay.
That's just his submission before this court, but that is not what happens on the ground.
From amongst the work charge employees, those who are sincere, those who are dedicated, regular, we used to give them scale of pay. That is the only criteria. That is, your leadership is will our merit comes seniority. Merit comes seniority, not seniority come merit. Merit come seniority. That way we used to choose for granting scale of pay.
That is given somewhere.
Very unfortunate. In the present case, petitioner was not enjoying that. That is how we cannot consider. That is the only point. That is the only point.
But what about the judgment?
In Annexure 4, Lordship, I have annexed a list of employees, 706 of them.
Annexure?
Annexure 4. This is
These
important.
they have got
Scale
of pay.
Yes, list of casual, ad hoc and work charge contingency, etc. who have been upgraded to scale of pay since 2000. This is in the petitioner's department. Now, since the year 2000, not since 1986. Because when I applied for this RTI, the department requested that since if you asked since 1986, it is very difficult for us. The records are all, most of them are not, we have found them, and then we have misplaced them, we don't know where they are now. So kindly, if you are agreeable to it, can we give from 2000 till that? So I said yes.
Okay.
Just because this is only in order to show before this honorable court that yes, there were so many similarly situated employees who were considered, but I was left out. Just for that point only, which is.
But then he said that it is on the basis of seniority come merit.
No, it's not. That is what. If there was a policy saying so, I would have placed that before this honorable court. And if there was a policy as.
No, he says merit comes seniority.
No, if that is the issue, then let it be placed on the record of this honorable court. They have been given up enough opportunity, and to the best of my knowledge, there is no such policy in the state of Nagaland.
Then what?
Because earlier, this case also, I appeared in this case also.
That's a single judge's case.
Yes. Here the division bench before the single bench, yes, I appeared. And here the additional advocate general appeared. During that time also, no policy was placed before this honorable court, showing that seniority come merit or merit come seniority is to be adopted for awarding scale of pay to the work charge employees. Nothing was placed. And today, till now, to the best of my knowledge, I have handled similar cases also before this honorable court. There is no such policy. And it is only the verbal submission of the learned government advocate.
In this judgment, of course, I have not read. This judgment says that whoever works for 30 years has to be given pension. Continuous period service of 30 years. Pensionary benefits needs to be given.
Yes. In that judgment, same as me, he has worked for 35 years. And that judgment is based on the decision passed by the Honorable Supreme Court in Talsibai, where Talsibai he served for 30 years. Talsibai was the head of Gujarat.
Where is the judgment?
It is referred in
Annexed.
that. Yes, it is referred in that. The citation is also given there. And
Talsi Bhai,
yes,
Dhanji Bhai.
yes, as well as Prem Singh was the state of UP 2019. 10 SEC. It's also
Achha.
yes. Now in that case also, when a work charge employee has served for 3 to 4 decades, then pensionary benefits must be awarded. That is a 3 judges bench decision.
What is that? Prem Kumar. What do you say?
Prem Singh versus state of UP.
That is also reflected here.
Yes, yes, my lord, my lord. And there are 2 earlier division bench decisions of this honorable court.
Prem Singh is not given here.
Prem Singh, it's given. I have checked.
Ah, yes, Prem Singh, yes.
Yes, yes.
2019.
Yes,
Okay.
my lord. And 2 other decisions passed by this honorable court. The division bench of this honorable court, that is Ipohal Singh and one Ramaswamy or Western State of Nagaland. In both cases, the direction was given for recolocation of the work charge employees who have served from initial appointment till superannuation, that is more than 30 years. And the division bench decision has also stated that these are beneficial schemes, welfare schemes, and it must be interpreted in a liberal manner, so as the benefit for whom it was intended actually reaches those persons.
And what did the division bench say about this memorandum? Those who have not been paid
Yes.
pay scale and continuous service will not.
They have also stated that the pick and choose policy was
Where is that
adopted.
finding? Can you show me from the division bench judgment?
The head note instead of
Not the head note, the paragraphs.
Paragraph 31. The division bench in Angpe has quoted another division bench decision with agreement.
Wait, 31.
Yes, paragraph 31.
Yes.
A division bench of this honorable court, also in state of Manipur versus Ipohal Singh.
Wait, I'm yet to take out paragraph 31. Yes. Ibohal Singh.
Reported in 1997 to GLG 209, echoed the same principle wherein it has been held as under. 12. We unequivocally.
Unequivocally.
Yes.
Of the view that the term contract.
Of the view that the term contract appointment must be terminable at some stage in their service. But if contract appointment continues uninterruptedly till the age of superannuation, as it happened in the case at hand, the character of appointment automatically changes and the employee has to be treated under normal government service rule, entitling them pensionary benefits. In the instant case, the stand taken by the appellant government that the respondents were on contract service and therefore even if they retire on attaining the age of superannuation, they will not be entitled to pension and other retirement benefits is unacceptable. If they are on contract service, their service could have been terminated when they were youthful and they could have gainfully employed in some other avocation. but then after using their entire services, strength out their energy. And when they are aged, old, and infirm, and incapable of functioning, allowing them to go empty-handed is an invasion of the mandate of Article 14 and 21. Right to life has been interpreted as right to live with dignity. Will have no meaning. The contention of the learned counsel for the appellants is therefore rejected as untenable.
Okay. Yes, Mr. Government Advocate, you submit that this case and the present case are similar in nature? This one?
Yes.
Yes. These are also in respect of work charge employees and the present case also. I have not seen. Here it is said whoever, of course, is too inhumanitarian, to leave somebody empty-handed after he worked for 35 years uninterruptedly.
That is why your ladyship, my submission, very unfortunate in that there is no office memorandum circular by the authority of the state to regularize a person who was working as a work charge employee in a fixed pay. In effect.
Something has to be done.
That is, because in absence of any policy decision by the state, how can a person be regularized? That is my only question. Otherwise, I leave it to the wisdom of your lordship to decide.
Technically, he is correct because the rule doesn't provide.
Yes.
But then.
Yes, but then the fundamental rights cannot be supplanted by the existence or non-existence of rules. And even if there is rule, and if it supplants Article 14 and Article 21, then this honorable court will come to the rescue of the petitioner.
Yes. Okay. These are all?
Yes.
Okay, I'll pass the judgment in the chamber.
My lord, my lord.
Because I've not gone through anything,
Yes.
you have just said.
And my lord, if my lord requires the copy of any of the decisions referred in the division bench
No, I
decision.
can. I'll have it. No issues. I'll have it. No problem. Okay, heard Mr. So-and-so for the petitioner and so-and-so. Rest I will dictate it in the chamber and you'll get the order.
My lord, my lord.
Disposed of.
My lord, if I may indulge, my lord, for paragraph 18, I believe is also important.
Paragraph 18.
Yes. Here they are discussing about.
This is the last matter. Oh.
Yes, this is the last matter.
Acha. That the paragraph 18?
Yes, paragraph 18 at page 394.
394.
Yes.
What paragraph 18 of the what? Your petition?
No, my lord. The judgment that I have placed.
Oh, acha. The judgment.
Yes.
Paragraph 18.
Yes. It appears at page 394. This is a reported decision, so I have printed out from the book.
Oh, this West Bengal?
No.
Anwar Ali?
No. Yes, just below that, paragraph 18 starts.
Oh, yes, I've considered it.
It may be mentioned here that in the impugned judgment, the learned single judge has observed as under.
And the one that you
Yes.
have given?
Yes.
Right.
Yes.
The single judge's order?
Yes. Here they are speaking about discrimination, a discriminatory policy being adopted. We are 380 employees of the department, of petitioner's department, were awarded scale of pay, but the petitioner was left out. Here in my case, 706. It's almost double. And that too only after the year 2000.
Why did discrimination, he said, on merit?
No.
This is what his submission is.
Yes, that is only his submission. But he must, if at all, if that is his submission, he must support it with facts. But he has not been able to place anything on the record of this honorable court. Whereas I have.
Now here.
In my petition,
Yes.
I have annexed the RTI
Huh.
reply, and I have categorically taken a stand that a pick and choose policy has been adopted, and there was discrimination, and there is discrimination.
Acha, where is your RTI reply?
Annex 4 to my writ petition.
Oh yes, that one you had shown.
Yes. Page 25 is the covering letter, and from page 26, the information starts. Now, if the information was furnished from 1986, then it will run from, the numbers will run more than 1,000. I can wager on that. But despite all this, I was left out. And I have served the maximum length of service.
What did the reply say? That with reference I am furnished herewith, the information sought regarding however date of appointment regard to cannot be furnished since appointment are done at respective date. You asked for the date of appointment of all the work, I mean the
Yes.
of all the
Yes.
work charge employees.
Yes, yes. In order to show that whether a junior has been regularized or not, that
But then
aspect.
it could not be given.
Yes,
From
yes.
2000 only they could give.
Yes, yes.
And you were appointed in 86.
Yes, my lord.
Okay, I'll examine the matter and I'll pass to you.
My lord, my lord,
By Monday you'll get it.
my lord. Deeply obliged.